Hello everybody. Yesterday was the 3rd of March of 2024 and I gave a lecture for les journées thématiques de INSERM and the Fondation Bettencourt-Schuller, and the theme I had to talk about was about law and science, and I decided, with their allowance, I thank them for that, to redo for this video this lecture. So I was talking to scientists, and definitely not attorneys, not lawyers, and I'm a lawyer myself. So in less than half an hour, let's talk about that, and it might be interesting for you. And I didn't have the courage to redo that in French, so I stick with English because it's the way I prepared it, and it's the way my PowerPoint has been built. And it started this way. Reminding that in law schools, since the Romans, it's really not new, students and professors love, with a huge level of self-satisfaction, to wonder whether law is a science or an art. Okay, it's a little bit silly, I admit. But to treat the topic this way, with the same question, seemed to me relevant, applied to scientists especially. So I kept that with two elements. First, the science of knowing environmental law, and two, the art of playing with it for scientists. Because law is often a kind of a maze, hard to go through for scientists. So, first element, the science of knowing environmental law, and of course I had to start back with the definition of law, which is a system of rules of a particular country, group, area of activity. Okay, it's basics, but it had to be reminded. And more widely speaking, it's just regulation of societies. And regulation of societies comes a long way. The big religious books were both religious, but also a list of rules to be applied also for the regulation of the group. The first proto-historic countries, civilizations, had their religious beliefs. And even when they were animists or pre-politists, then they had relationship with the springs, with the different elements that was a special relationship with nature. If you go in the big classical religious books we still have today, both in the Bible, see here the Deuteronomy, Greek and Latin cultures, the Islam, here is the Hadith, and or the medieval thinkers, because I love many things about her. I should give you a quote of Hildebert of Bingen. You see that nature and the relationship between human and nature and its environment is something not lightly taken in account, except that the cliche about it is to say, oh yes, but it's only made in the purpose of protecting human beings and health. It is true, of course, but when you think of what animist religions are, polytheist religions are, you can see that it is beyond that, and there's an idea of also of equilibrium with nature in many of these cultures. Even the very utilitarist civilization of Rome had meaningful cuts of water springs, for example. That came a long way. If we now focus on France, it's been taken into account by many norms, but the big classical way to start with this is to talk about Colbert's Ordinance of 1669. At that time, it was very important to build ships for military purposes, and therefore to regulate the use of woods. But very fast, many other things came with implied relationship with what would be today environmental law, like, for example, the Imperial Decree of 1810 about industrial smells. If you think of protection of nature, the ancestors of national parks or national or regional parks today, too, you have a big start in 1864 and many steps after. Same thing for forests and mountains. The first step, big step being 1860. But even before that, we had compensations of damages done between, vicinity laws. So you have a damage and you compensate it. That's really no news, except that it was not easily applied to pollution, what we would consider as pollution today. Of course, if we go more to what is today, we have big steps for water, 1964, 1992, 2006, 2014, and the more and more a wide conception of water. Petit cycle de l'eau with water, but today, GEMAPI, for example. The first ministry was in 1971. It was symbolic, but symbols matter. But today, the ministry in charge of environment has real big powers and includes everything that is equipment, roads, and all that. Two important laws were decided and voted in 1976 about protection of nature and ICPE, Installation classée pour la protection de l'environnement, and the Loi Bouchardot of 83 for public surveys, developed after, especially in 98 to 2012, but see also the Aarhus Convention in 98 about it. Mountain Law 85, Seaside Law 86, with the beginning of the idea of what is a landscape, paysage, that is still hard to define today, but with major steps about that, 93 too. Big independent authorities, agencies like ADEME, 1990, Noise Law, 92, industrial damages and many other things in that Loi Barnier, 95, many steps in energy. After we had a very important step with the Charte de l'Environnement, enforced 2005, but adopted 2004, that is part of our constitutional law. And one thing about it, we always, us lawyers, are annoyed when we see people using principe de précaution or principe de prévention all the time being mixed. Principe de précaution is, oh gosh, I know there are risks, I don't know much about this risk, I don't know how to regulate it, then I need to be extra cautious. And we're talking about principe de prévention when there are risks, I kind of know them, then I have less need of margin of security. What I'm saying is too much summarizing. I know. It's too simple. I know. Loi Grenelle, Loi Transition Énergétique, okay. Many things after in the last 10 years. But all that is annoying because it's a list of laws. It's only fun if you enter in these laws. So together, let's see the main frames of evolution of all that. One is the rise of planning. For zero artificialisation net, for example, is the idea that you have in the future to consume half less agricultural or forest lands than the last 10 years. And in 10 years, zero new artificialization. In terms of waste, there's been a lot of planning at the level of departments most of the time, and now today at the side level of regions. For water, there's a lot of planning too, and more and more. Since the 70s too, another big element, the rise of international law. But if you're not a lawyer, you have to make a distinction between what is international law. Does it have a direct effect or not? Or is it just talk? Depends. Two, European law, sometimes even the European law of human rights. That depends on the Conseil de l'Europe, but most of the time we're talking here about the EU regulations with a big distinction. Are we talking about a directive that the countries have a big margin of adaptation about? Or are we talking about a règlement which are to be enforced with a limited margin of adaptation? Again, if you're a lawyer, you're going to tell me I'm summarizing too much. Yes, this video is mainly for scientists. That's the way it's been conceived as a thought. Another element is that we developed, but it's no news because it's been the way mining law has been built since nearly always, but it's developed to many, many other fields, industries, but many others, drugs, water, sewage plants. The idea is that depending on the level of pollution, do I have to declare it or even have a special permit for it, autorisation? And more with special money to be put aside, kind of insurance system, in case of damages. And more also socialization of the payback of when damages are done, especially in many of these fields. Development of national parks, development of regional natural parks that are more in accord between human life and the environment. Also the rise since especially 10 years, but it's not that new, but it's really rising a lot, of helping and financing for repairs, moving to electric cars, bicycles, financing by big agencies like ADEME, OFB and all that, Agence de l'eau of course, thermal insulation of course. Another big evolution of this environmental law has been the rise of criminal law and the rise also of administrative justice that can organize, that can render decisions saying that as the French or more often EU law has not been enforced in France, then the French government or local governments, but most of the time the French government can be condemned. At least symbolically it is important. Big debates about that you can guess. There's also, it's less well known, the rise of administrative powers given to prefects or mainly to mayors in fields where in the past we could only use criminal law, like for example illegal landfills, dépôt sauvage de déchets. So all that was a very quick survey about the development of environmental law for non-lawyers. But that's the boring side. That's the very quick survey, a little bit annoying side. Now let's talk about what is really interesting. Is that, okay, not that you're all the specialist of environmental law after these certain minutes to listen to me. The question is, how do you play with it? Let's talk now about the art, for a scientist, of knowing how to play with the law. Law as a maze to get out alive, if possible, for scientists. The scientists will have different roles before a new norm is decided, a new legal standard, after a new norm, and having to cope with it himself when he has the scientist to justify of his actions or lack of actions. First, before a new norm is decided. Yeah, but what are we talking about? A law, in the French meaning of it, une loi, decided by the parliament. Are we talking about the rules made by administrations, décrets, arrêtés? Or are we talking about rules made by independent authorities? In my experience as an attorney for local or national governments, my experience is that it's very different the way you play with it if you're a scientist. First, let's talk about the law. Law, first, everybody sees the medias, Twitter, X, whatever. Everybody's going to say, oh, they all fight all the time. It's not that true. They fight in front of the medias, they kill each other on Twitter, and they debate harshly for big debates. Is their interest? It's political bullshit, but it's not what is the main job being done in the parliament. In the parliament, even today, many laws are decided by a vast majority that imply both the center, the left, and the right. At least, and sometimes even with the extremes. So let's not forget that if you have a reasonable topic to raise, you can have this kind of consensus, which matters. 2. Often scientists, especially young ones, say, okay, the question of lobbies, especially industrial lobbies. No. L'Académie de Médecine is a lobby. L'ordre des whatever professional order, including mine, are lobbies. And NGOs are lobbies. And scientific and medical authorities too. But for scientific and medical official authorities, the scientists know how it works normally. So that's not my play to talk about it. NGOs, associations for example, non-governmental organizations, are supposed to be natural advocates for scientists. Sometimes they are. But I see so many times scientists, even in the middle of their career, that still have a very idealistic ideas about associations, NGOs and all that. No, come on. They have their own agendas. And most of them, they got their own culture. And like in trade unions in France, syndicats, like them, they have their own culture and their own interest. And to negotiate, some do negotiate, some don't. Some like to negotiate, some don't even know to do it. And most often, especially in France, it is more playing their own interest to not negotiate. You raise more money and people talk more about you if you don't negotiate. That's maybe sad, but that's the way it is. Therefore, scientists need to have their own means of communication, whether you appreciate or not. Some NGOs' ways to communicate, there must be always a path for real serious communication of scientists' data. If we want a serious anchor to build reforms based on real scientific works and consensuses, and two, if we still hope that the science methods is still to be distinguished from writing opinions on Twitter, it's important to have this. And then it's interesting to have big consensus, real reports, serious job, and after communicate about it, but not in the same time and mastering it. We'll talk about that a little bit later. Another type of legal standards, of rules, can be provided by the administration. National governments or local governments. If it's national governments, it's going to be decrees or arrêtés. Then the ones who decide are the ministries or the local governments. It's a whole different culture. Much less hearings, much less reports, much less, reports yes, but internal ones often. Much less committees than for the laws. You have public surveys, you have things on the internet with debates before it's decided, but it's too late. If you want apply, if you have an impact on these future texts, you have to work before. And you work with people that sometimes think they know because they're lawyers, engineers, or from big schools. So that needs different ways to communicate than with members of the parliament. Still, I do want to point out that I started my job 34 years ago. Yeah, I know. And it really changed so much. It's incredible. These people listen to other people so much more than for 34 years ago. That's a thing. But the main thing to discover is that you've got very different ways to communicate, ministry by ministry. In my experience, a transition écologique, first of all, ministry works completely differently than the Ministère de la Santé. That's an example. So that is something to be a master. And another kind of ruler, of authority producing legal standards, norms, are independent authorities. And then you can have, for the drugs, biodiversity, for water agencies, ADEME, you got many of these. They have a technical culture. They know, they're part of your world, but they are very linked with the hierarchy, classical hierarchy of your world. And each one has different ways to communicate. That is to work with very different way than the two previous ones. The scientists can also have to work after a new norm, a new legal standard has been taken and enforced, and how to make it evolve. And of course, that opens the way to problems about science and medias. They have complex ways to move. Public reports and parliament committees evaluate what has been done much more than in the past. Maybe less than in other countries, but still they do much more. In the past, when with a report, the big joke was to say that it's gonna be left in a lobby or in a drawer. No, it's not the case anymore. And really, it's used. Today, if you say, members of parliament cannot pass a reform, they say in 6 months the government will have to make a report about that. Seriously, 10, 20 years ago, people didn't care. Today, they care, and members of the administrations, of the legal servants who's going to help the ministry to write that report will be a bit scared and ask people, sometimes people like me, to write the first drafts of it. But it will be examined by the parliament much more than in the past. So use it. You can even make it happen by meeting many members of parliament so they make their own reports. It takes years. It takes several reports for things to move, but it moves more than in the past. Another element that has to be kept in mind is that there's a rise of experiments. You can say, oh, let's experiment in, French Guiana or Brittany, this kind of other way to organize things, and in 2 years, we see what has been done and if it's good or not. That is developed much more in our regulation than in the past. It's not great, it's not working so well, but it's evolving in a good direction for this. But the problem for scientists, then, it's one of the most important things I have to tell you. I know it comes late in my speech, but let's focus. Is that scientists always make their studies and give people like me, members of parliaments, ministries, their results. And then we have a problem. Same thing in trials. Huh? It doesn't have to be only true. It has to be easily understood. A civil servant, an attorney, a judge, a member of the parliament will have to say, oh yes, of course I understand it. Of course it's logical. Your science sometimes is true without being logical. But in my world, it has to be turned in something that looks logical, that looks convincing. So my job, for example, often is to show science in a way that looks convincing without lying about it. If I lie about it, if I don't say what it is, it won't work and it won't be true. But if we say that in a scientific way, in a way that doesn't look convincing, it won't work either. So how to find a path that makes it work, being true, but in the same time understandable and looking logical. Believe me, it's an art, and we all spend all our career to try to make it work, especially in trials. When a law has been enforced, another moment where you scientists, can play a role is during trials. It can be a little trial somewhere in France because there's an expertise about building, about water, about pesticides, produits phytosanitaires, and all that. Yes, okay. It can also be the very chic thing, having in front of the Conseil d'État and all that, with written reports, because you won't testify. We're really not in American courts in my world. Yes, the problem we have is, let's say that in a very polite way, a real diversity in terms of quality of experts and in terms of independence of experts we can work with. So please, it's not very well paid, it's paid too late, it's not always flattering, but help us. Be there, especially in the medical field. We need you, and we need serious people. And now, last but not least, definitely not least, let's talk about law when it's a threat for you. After, what can happen to a legal standard or legal decisions in your hands when you have to be put on trial? It can be the company, it can be the administration you work in, it can be, if you are working in administration, that you took a decision and the judge will wonder whether it's legal or not. That judge can be the administrative judge, can be even on constitutional court, Conseil constitutionnel, if we're talking about a law. I'm simplifying, or about another topic, but constitutional rules apply to administrative decisions. Okay, it's legal. If it's illegal, you'll survive. It doesn't change your life. Change the life of your company, of your administration, yeah, a little bit. Another element is that, are you having to compensate damages? Students in law schools spend their life learning when it is the company or the administration or their own pocket that pays that compensation. Let's keep in mind something. 95% of the time is going to be the company or the administration that's going to pay the damages, or a socialization system. I'm simplifying by a lot. But globally, it's that. Except if you make a personal mistake, and then you know it. Real personal. And no, I want to focus on the criminal law, because then you're the one accountable. then you're the one who can have to pay a fine or maybe sometimes go in prison because there's been a pollution, for example, or other damage done, especially to the environment or to human health. You are working in a national authority like ANSES, decide special decisions of distance between agriculture with pesticides and habitations. Is it 5 meters more? That should be done. And after a few years, we discover that what your decision could cause cancer. You can be accountable in criminal law sometimes. Then, if it's not something you made on purpose, if it's human health or pollution that is at stake, it can be sometimes dangerous because you didn't respect the rules of filing a form for declaration or permit. Then it can be dangerous. But these are things you're supposed to know. The risk that you do mistakes like that is quite low in real life, except sometimes for mayors who have sometimes problems of pollution they cannot control. But what is the biggest risk is making a mistake by being not protective enough. Sometimes you have to choose between different protections. And then let's talk for a few minutes about another rule, which is the Loi Fauchon, the Fauchon law of the 10th of July 2000. Are you then in that law for something you didn't do on purpose, but still has an effect with victims, pollution, health, especially for doctors? Are you the direct cause of something? It's nearly never you. You allowed that drug, you're not the one who made a stupid thing in the use of the drug or the building of the drug one day. You can say something about rules of pollution and suddenly a mistake has been done by someone else most often. Then, if you're not the direct cause, you already have another distinction to make. If you are the indirect cause of that prejudice, did you violate a rule that has been fixed by a law or a règlement? Not good practices, not circulaire, not small law like that, but real, not standards of low value, but real standards that are been set by the law or by real règlement, arrêté, décret. Then, if you don't do that, if you have not respected that and have been an indirect cause of prejudice, you have to justify yourself. So that means that when you know there are special rules to apply who can cause directly very fast, not directly, but very fast damages, you have really to stick to it. Or if you do otherwise, you have to justify it. But if you're not in that situation, if you're down right in the scheme you have in front of you, then you can make mistakes. You just have not to make big mistakes. You can make mistakes as long as they are not big ones and are not faute caractérisées, which allows you, when you have norms, but not as precise norms, you don't agree with these norms, you think that you could do otherwise better, or you have to cope with real big problems that you think, therefore, that you can do otherwise. If you justify it, and there's been a damage, you can have a strong line of defense legally if you are in that green spot in what you see in the screen. So, if we finish all that, we had a survey about the law, we see how we play with it, and when we play with it, we can see that the scientist has to navigate between Charybdis and Scylla. If the scientist is far from the medias, is far from the rulers, it's going to be a pure scientist, but maybe an unusual one, because science is not heard, not turned into regulation. If you're working about environment, if you're working about global warming, if you're working about medical science, you want things to be applied to people and to nature, so it helps. But if you're too close from the medias, too close from the rulers, often it's going to go through a not serious enough percentage of real science in your communication, in what is said, and what is turned into law becomes law. So often the solution is to make real serious science. It's what has been made for global warming. Serious science, serious reports, and after working on communication after with real control, but well chosen messages each time, but after a real tough, serious scientific work. And then it's very hard not to be spoiled by communication or political experts, or even by attorneys like me. So that's very hard to do, but when it's well done, it works. So each of you will have to make his or her own way on this. And as the famous Mandalorian philosopher said, if it becomes your way, and if you keep this way, that's going to be the way. So thank you. That was been a long video. Normally I don't do videos in English so much because I work in France, but I wanted to recycle that long lecture I prepared because I found it was quite funny. I hope you had some of that fun. See you. You can subscribe there and see you next for another video, probably more in French. Bye.